Okay, welcome everybody to the Vocational Science of Freedom Saturday night Civics and Sovereignty class, which is hosted on the Vocational Science of Freedom Gilded server. And if you'd like to join the Vocational Science of Freedom Gilded server, you can do so by checking into the Vocational Science of Freedom YouTube page, clicking on the About section, and going to the link of the VSOF Gilded server, which will take you to our server. And just make sure that you hit apply in the upper left-hand corner here, and then you will be prompted to answer a few questions, and then your application will be looked over in the order in which it came in. And so tonight we'll be going over the Grand Jury Manual for California, as we have been for the past several weeks. And towards the end of the night, I'm going to cover USA versus Williams as well. So we left off on page 108, and you can get to the grand jury links and the handouts in this grand jury manual by clicking on the mega folder here in the server and downloading it. Get to page 108, and we left off with conduct of investigations. This is the little table of contents here, and I'll just skip that, and I'll just go through the sections that I feel are most important to check out here. So persons permitted to be present during session. No person other than those specified in Article 3, and you don't have to worry about these statutes, acts, ordinances, and codes when it comes to us forming a proper 25-member grand jury of the peerage. Every Roman civil law that deals with some way to control the grand jury is only a suggestion, because the vast majority of the grand juries that are out here and that are being run under statutory construction are being run, one, by infants. And if you want to know the definition of an infant, you can go look it up in United States Code, Title 1, United States Code, subsection 8, under the definition of person, and you will see that the definition of person is an infant. So when they talk about no person shall, la la la, well, they're talking about infants. They're not talking about we the people, which is why it's so important to get your Vocational Science of Freedom status doc set done so that your status is corrected. And that's just one of the 36 plus presumptions that the status docs correct on the public record. But that is a subject for another class. Persons permitted to be present during session. Basically, those that are in the grand jury and the officer having custody of a prisoner witness while the prisoner is testifying is permitted to be present during the criminal sessions of the grand jury, except the members and witnesses actually under examination. Members of the grand jury who have been excused pursuant to whatever section shall not be present during any part of those proceedings. No person other than the grand juror shall be permitted to be present during the expression of the opinions of the grand jurors. So that means that when you're deliberating, everybody has to get out, because it's nobody else's business but the grand jury members. Or the giving of their votes. So when they're voting, also, everybody else out on any criminal or civil matter before them. So, and one more thing about this grand jury manual that we're covering, if you happen to be listening online and this is the first class that you happen to click on. In California, there are 2 grand juries for each county. One's a civil grand jury, which deals with the purse strings of the county and other matters which we've covered in previous classes regarding what we've gone over with the civil grand jury. And then there's an indictment grand jury, or referred to as a criminal grand jury. So this is a civil grand jury manual that we're going over, just to make that clear to anybody that might not have gone back and listened to the previous grand jury classes before getting here. Okay, next section. Public sessions, matters affecting general public welfare, request, court order, conducting of examinations, secrecy of deliberation, and voting indictment. The grand jury, acting through its foreman and the attorney general, or the district attorney, may make a joint written request for public sessions of the grand jury. Right, make a request for. They can't order them to do anything, but they can say, hey, will you guys please look at this, that, or the next thing. The request shall be filed with the superior court. Now again, we've gone over this multiple times, but in case this is your first time listening, there's a huge difference between a superior court and inferior court. Okay, so the superior courts of record are courts that proceed according to the course of the common law. And you basically have three different kinds of courts in each state. You have inferior courts, then you have supreme courts, and then above that you have superior courts. And as I stated in the last class, towards the end when we went over the report from a criminal grand jury, there was clearly evidence to show that the superior courts are above the Supreme Court, because there was a judge that had went from being a state Supreme Court judge to then going to being a superior court judge. Now, that in and of itself doesn't necessarily prove that superior courts are above the other, but they are, without getting into it, which I've covered multiple times ad nauseum in previous classes. But the point is that the request shall be filed with the superior court. So everything that the grand jury does, when you're going to convene a grand jury, a proper 25-member grand jury of the peerage of the common law, you need to do it in a superior court of record. And all the courts in California, as per the California Constitution, are courts of record. But if you do not operate as a court of record, and you bring in statutes, acts, ordinances, and codes, or any other filth of Roman civil law, then it's not a court of record, because it has to operate like one. So that's just a little thing on courts, so you know the difference between superior court and inferior court. If the court or the judge thereof finds that the subject matter of the investigation affects the general public welfare, involve the alleged corruption, misfeasance, or malfeasance in office, or dereliction of duty of public officials or employees, or of any person allegedly acting in conjunction or conspiracy with such officials or employees in such alleged acts, the court or judge may make an order directing the grand jury to conduct its investigation in a session or sessions open to the public. So what's that telling you? That's telling you that, yes, if you're a grand jury, you can, if you wish, go ahead and open your sessions to the public, so that people can come in and they can see what you're talking about and see what you're doing. And you can even, as this grand jury manual has covered before, and we'll probably cover, I'm guessing, someplace in this section as well, about how the grand jury goes about publication of what it's up to. To continue, the order shall state the finding of the court. The grand jury shall comply with the order. Well, again, that's an aspect of what the statutes, acts, ordinances, and codes say. But when it comes to what you publicize, even in a common law grand jury, you should always be aware that the potential of libel, because you do not want to start publishing things into public newspapers and whatnot that would be considered a libel. And yes, even under the common law, there are certain things which a grand jury should not do, meaning to publicly denounce someone and say they did this, that, and the next thing before they had their day in court. Because again, a grand jury usually, but sometimes not, is just a accusatory body. They don't determine guilt or innocence, but there are some circumstances of which a grand jury can determine guilt or innocence, as in a writ of attaint, which I covered last class, so I'm not going to rehash it here. But, so, to continue. The conduct of such investigations and the examination of witnesses shall be by members of the grand jury and the district attorney. The deliberation of the grand jury and its voting upon such investigations shall be in private session. So again, everybody out. The grand jury may find indictments based wholly or partially upon the evidence introduced at such public session. So when you are having public sessions and someone walks in off the street that happens to be a public official of some sort, and they bring you information of any of the aforementioned things, corruption, malfeasance, misfeasance, so on and so forth, then the grand jury can act on that information. And also, the grand jury may choose to continue to investigate anything that's brought before them to whatever extent they feel is necessary, which we'll get into as to what the Supreme Court said in USA versus Williams towards the end of the class. So next section. Okay. Interpreter for disabled grand jurors. Yep, you can have an interpreter. That's fine. Subpoena of witnesses. Issuance. A subpoena requiring the attendance of a witness before the grand jury may be signed and issued by the district attorney. May be. But the foreman can do it himself or herself if she so feels. And then she would present the subpoena and have a magistrate sign it and say, yes, here, sign this, and we're going to serve it on whoever. And then you turn around and you give it to the sheriff's office and have the sheriff go serve whoever the subpoena is directed to so that they shall attend. So let me restart the sentence because it's the whole thing's one sentence. A subpoena requiring the attendance of a witness before the grand jury may be signed and issued by the district attorney, his investigator, or upon the request of the grand jury, by a judge of the superior court. Now that really should say magistrate of the superior court, but anyway, for witnesses in the state in support of the prosecution, for those witnesses whose testimony, in his opinion, is material in an investigation before the grand jury. Now, in his opinion, okay, you're talking about the district attorney, but also the opinion of the grand jury itself or the foreman. And for such other witnesses as the grand jury, upon an investigation pending before them, may direct. Again, as I said, the grand jury can subpoena anybody they damn well want to, which was pretty much the core issue with Hale versus Hinkle, wherein the grand jury subpoenaed, I think they subpoenaed the witness and subpoenaed documents from a officer of a corporation. So they subpoenaed the man, they subpoenaed the documents, said, show up with the documents, basically. He said, no, I'm not going to do it. Grand jury said, great, you can go sit in jail for a while. So they held him in contempt of the grand jury, and then this gentleman went and filed a habeas corpus and said, hey, court, get me out of jail. I'm not even charged with anything. They don't have the right to do this to me, blah, blah, blah. And the judge said, too bad. I can't even look at this because you're being held in contempt by the grand jury and they're above me. There's nothing I can do. I can't even entertain this habeas corpus. Basically because the grand jury could turn around and throw the judge for contempt of the grand jury as well and throw him into jail for a while if he were to try to go against the superior power of the grand jury. So I haven't gone over Hale versus Hinkle in totality. That might be something that we'll do next class. I'll just focus on that, and we'll cover USA versus Williams tonight, and then I'll go through Hale versus Hinkle and a few other particular cases that are extremely important regarding the powers of the grand jury next class, and then that'll probably be it for our grand jury classes for this time around, and then we'll rotate into the next class, which I believe it would be, banks and banking. So we'll go from class 6 into class 7 into banks and banking. So that'll be our next one up after we get through this. Okay, to continue. This basically is saying that the subpoena power is absolute. Okay, just remember that, because the subpoena power of a grand jury is the single greatest tool, in my opinion, that the grand jury can wield when it comes to getting to the bottom of whatever it is that's been brought before them. And also remember that a grand jury, on its own volition, doesn't have to have somebody from the outside. A grand jury of its own volition can just go, maybe we should go investigate the workings of the county jail. Or maybe we should go investigate and take a look at the financial records of a district attorney. They don't have to have any reason. They can do it simply on the basis they want to make sure that there's nothing going on that would be unlawful. All right, next section. Self-incrimination procedure. In any investigation or proceeding before the grand jury for any felony offense, when a person refuses to answer a question or produce evidence of any other kind, on the ground that he may be incriminated thereby, proceedings may be had under section so and so forth. We're going to get into this. This will be covered in USA versus Williams, because the idea that you have protection under the Fourth Amendment when it comes to a grand jury, you don't. The grand jury is above all that. The basic reason for it is because that the grand jury is the fourth branch of government, because it's mentioned outside of the constitutional structure of the three branches of government. So, and because of that, it is literally above any or all of the rules or protections that you would have against the government that was created by the Constitution, because it is not part of it. We, the people, are above government. And if we, the people, say, you have to come and produce evidence and going to be subpoenaed. There's even a part that happened, it's mentioned in U.S. versus Williams, where someone argued that the evidence that was being presented to the grand jury was procured by a violation of the Fourth Amendment. And the Supreme Court said, too bad. Doesn't matter. Completely irrelevant. So just know that the grand jury is most definitely above everything. So let's go on to the next page. All right, foreman, authority to administer oaths. The foreman may administer an oath to any witness appearing before the grand jury. Right, no problem there. Foreman, statement of matter to be considered and person to be charged. Retirement of prejudiced juror violation. Before considering a charge against any person, the foreman of the grand jury shall state to those present the matter to be considered and the person to be charged with an offense in connection therewith. He shall direct any member of the grand jury who has a state of mind in reference to the case to either party, which will prevent him from acting impartially and without prejudice to the substantial rights of the party to retire. Meaning, it's a good general thing before you start voting on an issue to say to everyone, as it's mentioned here, the foreman would say, hey, does anybody have, any connection with what's going on here? And if they do, then they can retire and not take part of that particular bill of indictment or that particular investigation, but still remain as a member of the grand jury. Next section, receipt of evidence. Subject to subdivision B of the investigation of a charge, the grand jury shall receive no other evidence than what is 1. Given by witness, produced and sworn before the grand jury. 2. Furnished by writings, material objects, other things presented to the senses. Or 3. Contained in a deposition that is admissible under subdivision 3 of section whatever. So again, these are suggestions. B. Except as provided in subdivision C, the grand jury shall not receive any evidence except that which would be admissible over objection at the trial. See, again, this is not applicable, because you'll see in U.S. versus Williams that the Supreme Court said, nope, it doesn't matter. So I'm not even going to bother with the rest of this, because the grand jury can take a hold of any evidence they want to, basically in any way that it came to them, even if it isn't a violation of the Fourth Amendment. So this whole section you can just throw out. Evidence for defendant, authority to exclude, weighing evidence, order for production of explanatory evidence. Okay, the grand jury is not required to hear evidence for the defendant, but it shall weigh all the evidence submitted to it, and when it has no reason to believe that other evidence within its reach will explain away the charge, it shall order the evidence to be produced, and for that purpose may require the district attorney to issue process for the witness. So when it comes to evidence that the defendant would have, it says it's not required to hear evidence, but it doesn't say that it can't hear evidence, because clearly, even if it said it, it would be invalid anyway. So the grand jury can hear evidence for the defendant. The grand jury can subpoena the defendant and basically have him or her explain themselves. And if the grand jury feels that the evidence that the defendant produces basically explains away the charge, right, then they can say, all right, we're not going to bring a bill of indictment, and you're free to go. Have a nice day. And there's something else too about this. I want to make a point here, which I'll get into in USA versus Williams again, that if a former grand jury said, no, we're not going to indict on that, a grand jury that follows them can open up the evidence again, take a look at everything again, do more investigations, and then, yes, if they wish to, bring an indictment. And it is not considered a violation of double jeopardy, because double jeopardy deals with the actual court case, meaning the determination of innocence or guilt. It does not apply to grand jury procedure. So just remember that. Next section, duty to inform grand jury of exculpatory evidence. Again, this gets back into what I was just talking about. If the prosecutor is aware of exculpatory evidence, the prosecutor shall inform the grand jury of its nature and existence. Well, good. Actually, I would keep that in there, because I would say of any grand jury that I would ever be on, yes, I want every single piece of exculpatory evidence that you have. And if it turns out that you didn't give it all to us when the trial comes, then I would hold the district attorney in contempt of the grand jury, throw him in jail for a while. Once the prosecutor has informed the grand jury of exculpatory evidence pursuant to this section, the prosecutor shall inform the grand jury of its duties under section whatever. If a failure to comply with the provisions of this section results in substantial prejudice, it shall be grounds for dismissal of the portion of the indictment related to that evidence. It is the intent of the legislature, by enacting this section, to codify the holding of Johnson versus Superior Court and to affirm the duties of the grand jury pursuant. Okay, anyway, we'll get into this again in USA versus Williams. Next section, sufficiency of evidence to warrant indictment. The grand jury shall find an indictment when all the evidence before it, taken together, if unexplained or uncontradicted, would, in its judgment, warrant a conviction by a trial jury. Makes sense. That's a good general statement. But again, pay no attention to the statute. Next section, report or recommendation only after own investigation. A grand jury shall make no report, declaration, or recommendation on any matter except on the basis of its own investigation of the matter made by such grand jury. A grand jury shall not adopt as its own the recommendation of another grand jury unless the grand jury adopting such recommendation does so after its own investigation of the matter as to which the recommendation is made, as required by this section. Again, don't worry about the requirement. There are no requirements. But as we saw last time when we went over the report of corruption from San Francisco at the end of last class, which you can go back and look at, that's exactly what they did. They went back, took a look at what a former grand jury had done, adopted their recommendations, and continued their own investigation. So they did exactly what this sentence says. So just to give you some historical background. All right, next section, declaration that evidence did not support indictment, declaration that person was witness. A grand jury which investigates a charge against a person and as a result thereof cannot find an indictment against such person shall, at the request of such person and upon the approval of the court which impaneled the grand jury, report or declare that a charge against such person was investigated and that the grand jury could not, as a result of the evidence presented, find an indictment. Exactly. So the grand jury can say, get out of here. We don't find any problems here, and there's no reason to continue to investigate. You're free to go. The report or declaration shall be issued upon completion of the investigation of the suspected criminal conduct or series of related suspected criminal conduct, and in no event beyond the end of the grand jury's term. Well, again, unless a grand jury that comes after them wants to reopen it and take a look at it again, then that would be a contradiction there as to what that's just said. B, a grand jury shall, at the request of the person called upon the approval of the court which impaneled the grand jury, report or declare that any person called before the grand jury for a purpose other than to investigate a charge against that person was called only as a witness to an investigation which did not involve a charge against such person. The report or declaration shall be issued upon completion of the investigation of the suspected criminal conduct or series of related suspected criminal conduct, and in no event beyond the grand jury's term. Yeah, okay. Fine. Okay, next section, Title V, the pleadings. And again, I'm just going to skip it, just get into the sections here. Concurrence of jurors, number, endorsement. An indictment cannot be found without the concurrence of at least 14 grand jurors in a county in which the required numbers of members of the grand jury prescribed by section. Now that's interesting because they actually got the number right. Well, sort of right. When you have a 25-man grand jury and half of that, they say 14 here, so they're actually going one over, which is fine. But the fact that they don't have 25 to begin with is the problem. And the fact that it's made up of citizens of the United States, which are subject to the jurisdiction of Congress and not sovereign. Okay, so at least 8 grand jurors in a county in which required number of juries 11, at least 12 in juries. Okay, in other counties, right? Yeah, you see, is 23. Okay, so the members of the grand jury prescribed in section blah, blah, blah is 23, right? Not 25, 23. So they always stop short. Next section, same names of witnesses, insertion or endorsement at foot of indictment. When an indictment is found, the names of the witnesses examined before the grand jury or whose depositions may have been read before them must be inserted at the foot of the indictment or endorsed thereon before it is presented to the court. Interesting, right? Endorsement, they have to endorse it. That's the same part and parcel of the process of what we do with the vocational science freedom status docs. There's an endorsement that goes on the backside of your birth certificate. Why? Because you have to claim it, because it's basically a check. But again, that's material for another class. Next section, presentment and filing. Prohibition against recommendation of amount of bail. An indictment, when found by the grand jury, must be presented by their foreman in the presence to the court and must be filed with the clerk. No problem there. No recommendation as to the dollar amount of bail to be fixed shall be made to any court by any grand jury. Well, yeah, that actually makes sense because it comes under the full commercial liability of the magistrate to determine that and whether or not it's excessive or not, and if that issue to be sued out, that it say it was excessive, would be solely focused at the magistrate that signed it, not the grand jury. So that makes sense. Next section, defendant not in custody, procedure upon finding. When an indictment is found against the defendant not in custody, the same proceedings must be had as are prescribed in subsections so on and so forth, inclusive against the defendant who fails to appear for arraignment. So when the grand jury finds an indictment against someone who hasn't yet been arrested, they're not sitting in jail. Basically, they're saying that it's inclusive against the defendant who fails to appear for arraignment. The defendant doesn't show up for arraignment. The findings of the grand jury still stand, is basically what that says. The following pages contain the code sections referred to in section of the penal code. Okay, this is all penal code stuff and how they're defining things in their municipal law, their Roman civil law. So I'm not really going to bother with any of this because it's all legalese that doesn't apply to us and it's not common law. Oh, I'll read this for a second because this is interesting. Okay, powers in general. A county is a body corporate and politic, has the power specified in this title and such other necessarily implied from those expressed. I'm going to make a point here. Between the difference between implied and expressed powers, there is no such thing as an implied power. Period. Full stop. If we the people have not decreed it to be so, if we have not vested power to someone as an expressed power here, constitutionally, it cannot be implied. Now, the bastard that made sure that there were all kinds of quote-unquote implied powers in the Constitution was Hamilton. But there is no such thing. There is no such thing as an implied power. It either is or it is not. And this will get into when we cover the treatise on de facto government and show how that everything that's under color of law, everything that's implied, has absolutely no force or effect over we the people. And we can crush it into oblivion anytime we want to. It's interesting that they do lay it out here. And then they try to take an implied power. Yeah, well, like I said, none exists. Yeah, I think I'm just going to, because this is cases about getting into the corporation, about the county being sued, which of course you can always sue the county under the common law because it's the man that you're going after because he's exceeded his jurisdiction. Oh, this is interesting. Manner of exercising powers. Now, in the last class, we were talking about and going over the Board of Supervisors and showing how, in this grand jury manual, they were talking about how the Board of Supervisors has the ultimate, the end authority about everything. Well, no, it's a bunch of corporate officers controlling that little corporation. But it's telling how this reads. A county may exercise its power only through the Board of Supervisors, or through agents and officers acting under the authority of the Board of Authority conferred by law. So the Board of Supervisors, the Board of Authority, they all have these boards, these corporate boards. So it's showing you the corporate structure of a county. So just to make a note of that. Contracts is sort of violating any contract, authorization, allowance, payment, or liability to pay made or attempted to be made in violation of law is void and shall not be the foundation or basis of a claim against the Treasury of any county. How about shall not be the foundation or basis of a claim against any one of the people? What's good for the goose is good for the gander. When they try to say, just walk into any court and say, Your Honor, I object to all further proceedings until proof of a contract is brought forth on the record. And this is the thing, too. Statutes, acts, ordinances, and codes, all the aspects under maritime admiralty law, everything under the law merchant, it's all contractual. Whether it's an aspect of contract by your consent, that you agree to be governed by such filth, by stating an inferior status like a citizen of the United States, or if it gets to some sort of direct contractual issue, like you went to go get a license to go do something that was by itself inherently lawful to do to begin with, well, then that's a contract. But here's the kicker. Unless you've had any contracts with the corporate state, prior to Nixon dropping the gold standard, every single contract that has happened since that particular event happened is not a lawful contract. Because it says right here, or made or attempted to be made in violation of law. Okay, great. What does Article 1, Section 10 say in the Federal Constitution? It says, no state shall make anything but gold and silver as tender of payment of debt. Okay, so if you use worthless Federal Reserve notes to enter into a contract, it's not a contract. You didn't give anything of lawful consideration because they're worthless, which is exactly what the Jerome Daley case said in Minnesota. It's referred to as the Credit River decision, but you can look it up, and what that jury said and what the judge said is that, yes, all contracts that have Federal Reserve notes as an aspect of its quote-unquote exchange are invalid, period. So you can always think about that from the standpoint of contract. If they ever try to bring it up, just go, yeah, what are you talking about? There's no money. I didn't exchange anything, so therefore it's an unlawful contract. So they don't ever want to cross that issue. But anyway, all right, let's see if there's anything else in here that's worth reading. Oh, okay, here's a section that's actually worth looking at. Well, actually, this is an interesting part too. Please note that the above sections, which is all this government code garbage regarding their financial stuff, of the government code provide for removal of local government officials from office by trial after the grand jury has voted an accusation against the official. Well, that should actually say indictment. This procedure is not followed in San Francisco since the charter, right, because San Francisco is a chartered corporation, provides an exclusive method for removal of elected officials from office. So you see how just in reading this, you can understand that the municipal law, which is the same thing as Roman civil law, is foreign to us and has nothing to do with us. And that you're dealing with corporate government. Next section, oath to witness. Again, you can skip the code there. And you can alter this as you see fit. The grand jury can. So this is an oath for a witness. You do solemnly swear that the evidence you shall give in this investigation now pending before this grand jury shall be the truth, the whole truth, and nothing but the truth, so help you God. Either the work affirm or declare can be substituted for swear. Yes, because some people have a problem with quote unquote swearing. It's a biblical thing, which I get. So you can alter those. When a person is sworn who believes in any other than the Christian religion, he may be sworn according to particular ceremonies of his religion. If they're be any such, right? Which is what I was just getting at. Oath to interpreter, oath to translator, oath to court reporter, citation for failure to answer question when subpoenaed. Okay. This is, again, getting back to Hale versus Hinkle, but in the event that a witness subpoenaed to appear before the grand jury refuses to answer a question or questions, the witness should be told, we will have you cited for contempt of court for failure to answer the following questions. Repeat the questions for the record. The failure to answer is then to be brought to the attention of the presiding judge for further action. Right. You can hold them in contempt. So even the civil grand jury manual makes it very, very clear that if he didn't answer it, tell him you'll hold him in contempt for failure to answering it, and then repeat the question. Okay? So even in the civil grand jury manual, it tells you can do this. Miscellaneous statutes, not even going to bother. This will pretty much conclude the civil grand jury manual for California. Hooray that we're finally done with this thing. Now let's open up and take a look at USA versus Williams, and I'll blow this up so that everybody can read it. And I'm just going to cover basically the parts in here that I have highlighted. I'm not going to try to read the whole entire case in its entirety, or the holding, because this is just the holding. It's not the whole case, but it's 27 pages. But again, it's I'm not going to try to go through the whole thing. I'll just scroll through until I get to the various different points here. So how did this happen? Okay, what's the case? Just the general thing. Respondent Williams was indicted by a federal grand jury for alleged violations of 18 U.S.C. 1014, which, of course, all of 18 U.S.C. has never been properly codified into law, in case anybody isn't aware of that. On his motion, the district court ordered the indictment dismissed without prejudice because the government had failed to fulfill its obligation under circuit precedent to present, quote, substantial exculpatory evidence, close quote, to the grand jury. Following that precedent, the Court of Appeals affirmed. Held. The argument that the petition should be dismissed as improvidently granting because the question presented was not raised below was considered and rejected when this court granted certiorari, which is the Supreme Court, and is rejected here again. The court will not review a question that was neither presented nor passed on below. Well, obviously, that's just an aspect of appellate rules in general. But there is no doubt that the Court of Appeals passed on the crucial issue of the prosecutor's duty to present exculpatory evidence to the grand jury. It is appropriate to review an important issue expressly decided by a federal court where, as here, although the petitioner did not contest the issue in the case immediately at hand, it did so as a party to the recent proceeding upon which the lower courts relied for their resolution of the issue, meaning the issue of the exculpatory evidence, and did not concede in the current case the correctness of that precedent. So a district court may not dismiss an otherwise valid indictment because the government failed to disclose to the grand jury substantial exculpatory evidence in its possession. Again, like I said, that goes back to what we were just reading in the grand jury manual. If the grand jury themselves goes to the prosecutor and says, we demand, that's different. But here it says the district court may not dismiss an otherwise valid indictment because the government failed to disclose to the grand jury, basically of its own volition, not that the grand jury ordered that they disclose, but that he or she just didn't give it to them. They can't dismiss it on that. But if the grand jury demands the exculpatory evidence and it's not given to them, well, then the grand jury can hold the prosecuting attorney in contempt until they get it, whatever else. But not what happened here. Okay, he just didn't give it to him just because he didn't feel like it. Or he didn't do it because, right? And the grand jury didn't demand it. Imposition of the Court of Appeals. Disclosure rule is not supported by the courts. Inherent, quote, supervisory power to formulate procedural rules not specifically required by the Constitution or the Congress. This court's cases relying upon that power deal strictly with the court's control over their own procedures. Not the grand jury's procedures, but their own procedures. Clearly showing that the grand jury procedures are outside of their control. Whereas the grand jury is an institution separate from the courts. Remember, people, I am reading from a Supreme Court decision, over whose functioning the courts do not preside. Any power federal courts may have to fashion on their own initiative rules of grand jury procedure is very limited and certainly would not permit the reshaping of the grand jury institution that would be the consequence of the proposed rule here, meaning they can't change it. The Court of Appeals rule would neither preserve nor enhance the traditional functioning of the grand jury that the, quote, common law of the Fifth Amendment demands. Skip down to the next note. You guys can feel free to read all of U.S. versus Williams. It's all interesting, but I'm just going to go through where I've got my notes here. Respondent does not contend that the Fifth Amendment itself obliges the prosecutor to disclose substantial exculpatory evidence in his possession to the grand jury. Instead, building on our statement that the federal courts, quote, may, within limits, formulate procedural rules not specifically required by the Constitution of Congress, he argues that imposition of the 10th Circuit's disclosure rule is supported by the court's supervisory power. We think not. The Supreme Court said, nope, absolutely not. Hasting and to the cases that rely upon the principle it expresses deals strictly with the court's power to control, again, what? Their own procedures, not the grand jury's procedures. Okay? Because the grand jury is an institution separate from the courts, over whose functioning the courts do not preside, we think it clear that, as a general matter at least, no such supervisory judicial authority exists, and that the disclosure rule applied here exceeded the 10th Circuit's authority. No person other than the jurors may be present while the grand jury is deliberating or voting. That was clearly in the manual. Okay, that some of the misconduct alleged in Bank of Nova Scotia versus United States was not specifically prescribed by rule, statute, or the Constitution does not make the case stand for a judicially prescribable grand jury code. Pretense to this was that the Supreme Court was talking about how they keep getting asked to create rules for the grand jury, and they're like, we can't, so stop asking. Okay, rooted in long centuries of Anglo-American history, the grand jury is mentioned in the Bill of Rights, but not in the body of the Constitution. It has not been textually assigned, therefore, to any of the branches described in the first three articles, which is what I mentioned before. It is a constitutional fixture in its own right. In fact, the whole theory of its function is that it belongs to no branch of the institutional government, serving as a kind of buffer or referee between the government and the people. The grand jury, although the grand jury normally operates, of course, in the courthouse and under judicial auspices, its institutional relationship with the judicial branch has traditionally been, so to speak, at arm's length. Judges' direct involvement in functioning of the grand jury has generally been confined to the constitutive one of calling the grand jurors together and administering their oaths of office. That's it. That's all the court's functioning is. Once they're in, the grand jury's formed, the oath is taken, that's the end of it. They take over from there. A grand jury's functional independence from the judicial branch is evident both in the scope of its power to investigate criminal wrongdoings and in the manner in which that power is exercised. Quote, unlike a court, whose jurisdiction is predicated upon a specific case or controversy, the grand jury can investigate merely on suspicion that the law is being violated or even because it wants assurance that it is not. Again, this is the Supreme Court talking. It need not identify the offender it suspects or even the precise nature of the offense it is investigating. Do whatever it wants to. The grand jury requires no authorization from its constituting court to initiate an investigation. See Hale, that's Hale versus Hinkle, by the way, supra. Nor does the prosecutor require leave of court to seek a grand jury indictment. Right? So anybody can be a prosecutor of their own case, come to a grand jury and say, look, I want to prosecute this guy. This is what he did, yada, yada, yada. Here, I want a true bill of indictment against him. Grand jury looks at it, goes, yeah, looks good. Here's your true bill. Say, thanks, good. Right? And then warrant of commitment is created, and then they do arraignment, and the trial court then does the prosecution. But anybody can do that. The term the prosecutor does not mean a state officer. It just simply means who is ever prosecuting the case. And as I mentioned last class, in the history of English jurisprudence, everyone used to prosecute their own wrongs. There was no office of the district attorney or the attorney general or anything of that kind. A free man has a right to his own court, which is clearly stated in the Magna Carta. I forget what article it is, but it says basically that there shall be no writ of precipice filed for a free man to lose his court, or something to that extent. What did that mean? It means every free man had the right to prosecute wrongs against him. So he was the prosecutor. All right, to continue. And in its day-to-day functioning, the grand jury generally operates without the interference of a presiding judge. It swears in its own witnesses and deliberates in total secrecy. Even in this setting, however, we have insisted that the grand jury remain, quote, free to pursue its investigations, unhindered by external influence or supervision, so long as it does not tranche upon the legitimate rights of any witness called before it. Well, in Hale versus Hinkle, that's kind of laid out. Well, no, actually, they didn't tranche over the rights of the guy in Hale versus Hinkle, because the power of the grand jury to subpoena supersedes any protected right in the Bill of Rights. So this statement is technically correct, but you got to realize that they're above all of that anyway. Recognizing this tradition of independence, we have said that the Fifth Amendment's constitutional guarantee presupposes an investigative body acting independently of either prosecuting attorney or judge. Okay, next one. The Double Jeopardy Clause of the Fifth Amendment does not bar a grand jury from returning an indictment when a prior grand jury has refused to do so, which I stated earlier. We have twice suggested, though not held, that the Sixth Amendment right to counsel does not attach when an individual is summoned to appear before a grand jury, even if he is the subject of the investigation. So again, right there, it's showing that the Bill of Rights is not available to you when you're the subject of a grand jury investigation, because the sovereign people themselves are doing whatever they feel they need to do, and they're above all that. Our cases suggest that an indictment obtained to the use of evidence previously obtained in violation of the privilege against self-incrimination is nevertheless valid. Again, like I said, violation of Fourth Amendment, who cares? Tough shit, you can use it anyway. Given the grand jury's operational separateness from its constituting court, it should come as no surprise that we have been reluctant to invoke the judiciary's supervisory power as a basis for prescribing modes of grand jury procedure, obviously. Over the years, we have received many requests to exercise supervision over the grand jury's evidence-taking process, but we have refused them all, including some more appealing than the one presented today. A grand jury witness faced questions that were allegedly based upon physical evidence the government had obtained through the violation of the Fourth Amendment. We rejected the proposal that the exclusionary rule be extended to grand jury proceedings because of, quote, the potential injury to the historic role and functions of the grand jury. Well, simply, they just can't do it, because again, grand jury is above government. But again, you see how you have no protection from a grand jury? This is absolute, pure, raw, sovereign power. Whatever the hell you feel like you have to do it. And nothing can stop you, because you are the absolute highest authority in this constitutional republic. Or I should say, the several constitutional republics of the states, because the United States is a trust. Okay, these authorities suggest that, well, the United States is technically also a corporate body under the District of Columbia, and the United States of America is a trust. So, yes, exactly. We have the power, but we just forgot how to use it. Respondent makes a generalized appeal to functional notions. Judicial supervision of the quantity and quality of the evidence relied upon by the grand jury plainly facilitates, he says, the grand jury's performance of its twin historical responsibilities, i.e., bringing to trial those who may be justly accused and shielding the innocent from unfounded accusations and prosecution. Again, that gets back to where the grand jury has the right to demand from the prosecutor any exculpatory evidence which they might have. Any evidence that they might have that would prove his innocence and that he didn't do it, if the grand jury demands it, the prosecutor has to give it. If he doesn't give it, or she doesn't give it, hold him in contempt. Next one. Oh yeah, this is an interesting one. That has always been so, and to make the assessment it has always been, through sufficient to hear only the prosecutor's side. This is from Blackstone's commentaries. As Blackstone described the prevailing practice in the 18th century England, the grand jury was, quote, only to hear evidence on behalf of the prosecution. Again, back then, under English jurisprudence, who was the prosecution? Whoever the hell was bringing the suit. For the finding of an indictment is only in the nature of an inquiry or accusation, which is afterwards to be tried and determined. See Blackstone's commentaries 31769, which I highly suggest everybody go read all of it. Just go read all of Blackstone's. You'll probably, by the time you get done reading Blackstone's and fully understanding it, you'll have a higher education of law and the history thereof from English to American jurisprudence than 90% of judges and attorneys. Unless the 10% that do enjoy and study the common law, okay, you're going to have to read more than just Blackstone's. But, yeah, you'll have 90% of them beat. Okay, next note. According to the description of an early American court, 3 years before the Fifth Amendment was ratified, it is the grand jury's function not to, quote, inquire upon what foundation the charge may be denied, or otherwise to try the suspect's defenses, but only to examine, quote, upon what foundation the charge is made by the prosecutor. That's true. But again, the grand jury can also go the other route too. Got it both directions. Okay, respondent acknowledges, as he must, that the common law of the grand jury is not violated if the grand jury itself chooses to hear no more evidence than that which suffices to convince it an indictment is proper. So, whatever they want. There is yet another respect in which the respondent's proposal not only fails to comport with, but positively contradicts the common law of the Fifth Amendment grand jury, period. Motions to quash indictments based upon the sufficiency of the evidence relied upon by the grand jury were unheard of at common law in England. You want to go drop an indictment on someone for the evidence that you find with their unlawful behavior in office, and they come back and they say, well, wasn't sufficient evidence. Too bad. We're at common law here. We don't need it. We think you should be tried anyway. Not going to get a motion passed to quash an indictment. And if a judge does pass a motion to quash an indictment to try to protect one of his buddies, just bring this one up and slap the judge in the face and say, you sure you want to do that? Let him think about it a little bit. Okay, no case has been cited, nor have we been able to find any, furnishing an authority for looking into and revising the judgment of the grand jury upon the evidence for the purpose of determining whether or not the finding was founded upon sufficient proof, or whether there was a deficiency in respect to any part of the complaint. Again, total power. It would run counter to the whole history of the grand jury institution to permit an indictment to be challenged on the ground that there was an inadequate or incomplete evidence before the grand jury. The mere fact that evidence itself is unreliable is not sufficient to require dismissal of the indictment, and that, quote, a challenge to the reliability or competence of the evidence presented to the grand jury will not be heard. Again, like I said, they're above all that. That's motions for the trial court. Dissenting opinion, Stevens, O'Connor, Thomas. I don't even think I even made any notes in here because the court purports to support this conclusion by invoking the doctrine of separation of powers and citing a string of cases in which we have declined to impose categorical restraints on the grand jury. Exactly. This court has, of course, long recognized the grand jury has wide latitude to investigate violations of federal law as it deems appropriate and need not obtain permission from either the court or the prosecutor. Bam, right there. Hale versus Hinkle. Get the point? So, violations of federal law. Guess what? Form a federal grand jury. Violations of state law, form a state grand jury. Violations of any other common law, it's just the grand jury of the county. Just get your venue right. Because you shouldn't be going over federal court issues in a county common law grand jury. You should state that it is a federal grand jury. Okay, neither justice nor the concepts of fair trial requires such a change. Oh, no, sorry, that's the top part. It may also invoke its supervisory authority to fashion other limited rules of grand jury procedure. It concludes that it has no authority to prescribe standards of prosecutorial conduct before the grand jury. Again, nothing can tell you what to do. You have all the power. I'll just leave it at that. Feel free to have fun reading USA versus Williams, and obviously have fun reading every single other handout that's in the grand jury folder, because if you read everything that's in this grand jury folder, as far as what I've put up for the vocational science of freedom, which we've gone over a lot of this in various different classes, but if you just read all of this by yourself and look at my notes and go back and rewatch the civil grand jury class that we've been doing through this entire California grand jury manual, you'll get a tremendous education as to what your powers are, what the procedure is, what you can do, what they can't do, and truly be able to wield your sovereign power in a way that we can take back our republics and clean them up. With that, if anybody has any questions, take a look at chat here. Yeah, Carrie, the reason why they try to cover all this up is because of the absolute power of the grand jury. It's stunning how dumbed down the American people have become through the Prussian education system that has completely eviscerated civics out of its curriculum. And of course, civics, what we're teaching here, is the study of one's rights. What are your substantive rights and what can you do with them? And if you don't know, you can't use them. There's a maxim of law that actually states that he who slumbers on his rights has none, which pretty much is the case. If you don't know what your rights are, clearly you can't exercise them. And, by the way, that's all anyone can ever do with a right, is exercise it. Can't give up a right. You can either exercise it or choose not to. That's your choice, though. No one is forcing you not to choose not to do so, or forcing you to choose to do so. Completely up to you. It's just a violation of your own volition. From a standpoint, if you actually feel like, oh, I'm subject to Roman civil law, and they told me to do this, and they told me to do that. Well, go back and read the letter from the grand jury foreman that we read a couple classes back. That was clear language of frustration of what the grand jury foreman was having to face with the prosecutor, who was clearly a Khazarian mob, Luciferian piece of shit. But just on the side note, you could totally tell that that prosecutor thought that he owned the grand jury. Well, what do you do with someone like that? You crush them. You throw them in jail and say, you can sit in jail until you wise up, buddy. Until you can come back in here with some sort of respect. Because we are running this grand jury, not you. So yeah. So, Chief, what are you saying? If a police officer violates the Fourth Amendment of someone's privacy without a search warrant and finds a stolen weapon, can the DA seek an indictment against the one that had a legal weapon, since the grand jury can use any evidence, whether or not that yes. The answer is yes, Chief. The answer is yes. Now, what would happen, the protection that would happen, okay, the protection part of it doesn't happen at the grand jury level. Because, why? Because the grand jury is just an accusatory body. The protection part of it would come at the trial level. And you would file a motion to dismiss. Well, you'd file a motion to strike the evidence, or you'd file a motion to strike the testimony of the officer. You would file your interrogatories, basically demanding that the district attorney answer, does an officer have to abide by the Fourth Amendment when exercising a search warrant? If a search warrant was created unlawfully, is it a valid search warrant? Right? These are interrogatories that you would give to force the district attorney or whoever's prosecuting to answer. And of course, when they can't answer them, then you do a judicial notice stating that the other side has clearly, been stuck with, or basically that they stipulate to this aspect of law. So everything's handled on the trial jury side of it. That, yeah, you do a motion to dismiss. The main thing that you would do would be that you would file a countersuit or a counterclaim for the officer exceeding their jurisdiction. So you say, you've exceeded your jurisdiction. This inferior court has no jurisdiction. because what you obtained unlawfully. So now you have to prove jurisdiction to my superior court that you followed the common law. You didn't. So case dismissed, right? So that's ultimately how that gets taken care of. No, I mean, the way you directly worded your question, the answer is yes. They can use the evidence, whether that evidence was obtained unlawfully or not. Which gets into a really gray area because, in a weird way, could you, as a grand jury, hire for, say, some very, very crafty private investigators that wouldn't necessarily be subject to the Fourth Amendment? Yeah, you could. And with that, yep, I'll call it a night. Thanks for showing up, guys, and I'll talk to you later.